Page 40
of the plaint.
That is Annexure D.
Yes, my lord, and please look at paragraph 5 of that letter. They want to, my lord, Hanuman Cotton shares. And, my lord, innocently they are telling your lordship, A, I won't give a copy of the plaint. B, I'm going to file an affidavit. And the language of the affidavit is that I state that as per the records, no shares are pledged by the plaintiff to the defendant bank. What about this, my lord, is the question I asked. This is fraud on court. You should have come clean before your lordship and said that I'm sorry, but there was an offer for pledge, nothing was given. Lord, this is most unfortunate, my lord. My lord, I'll tell you, lordship, my lord, what has happened. They are in the process of doing this. My information was correct. When I come, my lord, your lordship tells them, clarify. I say, I'll withdraw and go away. I was ready to withdraw and go away. Now, my lord, I find that they're not indicated, they're filing an affidavit, nothing has been done. But nothing is being said as nothing will be done. The affidavit, my lord, is worded in this way. I state that as per the records, no shares are pledged by the plaintiff. They can be pledged. My lord, they'll get rid of me this way today, and my lord, they'll accept a pledge tomorrow. And my lord, I have filed my application to show that they have no right in respect of these shares. Company Law Board has held that they have no right in respect of these shares. They've been transferred to me. My lord, this being the situation, my lord, I would humbly pray that kindly, my lord, two things are possible. A, my lord, if your lordship records that their stand is that no shares of Hanuman Cotton and Hanuman Foundry will be accepted as pledged by the defendant number 2. I'll, my lord, immediately withdraw my application and walk away. If not, my lord, to protect my property, my lord, kindly permit me to be added, because my property is being sought to be alienated in this way. And what is, my lord, shocking is that when this issue is brought before your lordship, they take a stand that no, we are not concerned with these shares. While, my lord, the pledge itself records, the plaint itself records this. But this is the shocking. If they had shown this to your lordship and said that, well, very well, nothing has been done, nothing will be done, there's nothing for him to worry about, I would have withdrawn and gone. But, my lord, the concealment is what, my lord, makes me extremely, my lord, apprehensive about what is happening.
Where is the defendant?
My lord, defendant
Defendant is supposed to file affidavit.
Lordship, I have filed the affidavit that nothing has been pledged, and this is an offer letter. This is an offer letter given by the plaintiff to the defendant, which is not accepted. They have given us checks for this offer letter for one-time settlement, and those checks are bounced. And for that reason, they come up to your lordship. But these offers are not been accepted. So nothing comes up.
But that is here.
That is here, which is not accepted.
How can I know? How this can know? This court can know?
That
If
the offer
his
has not-
shares are involved in this case, then he must have a locus
It is
standing.
not involved. They has just offered the defendant, but we will not accept
That
any
is-
share.
Even if it is not offered, this is in record.
This is in record, which we have not
But
accepted.
why have you done that? Why have you said that is not placed, not
No, it is not pledged.
opposing that?
But it is not pledged. They have not pledged. We have not accepted the pledge.
In all these four, this is there.
No.
That's what, my lord, I am told. That's what I am told. They're not giving me a copy of the plaint. Let them, my lord, give me a
FCCS
copy.
155.
Yes.
What about other plaints?
My lord, let them give me a copy. I'll, my lord, immediately.
Let me see the plaint.
My lord, may I just make my humble submission?
Yes,
Mr.
let
Chaudhary,
this to court.
Mr. Chaudhary had initially submitted that the shares were already pledged. The application is based on that premise. Then I come up with an affidavit saying that there is no shares pledged. The defendant comes up with an affidavit saying no shares pledged. Mr. Chaudhary does not have a copy of the plaint but knows what is there in paragraph 5 at page 40. He does not have. He should not be having. He's not a party to the suit. His application is for addition of party. Only after that order is allowed, then he's supposed to get a copy of the court proceedings. But today he knows. He's made submission with respect of without disclosing how he has been able to get it.
We have discovered that
And if he's placing his application, let him place. We will contest this application. Affidavits are exchanged. My lord, there are certain principles under which, my lord, an application for
The
addition of
principle
party
that-
can be added. We can hear out the application itself, my lord.
Yes,
If my
that
lord
should be
feels
done.
that they need to be added, they are a necessary party, then of course, my lord will add. But let them first demonstrate how they are a necessary party on the basis of speculation that shares today not pledged, but in future it can be pledged.
Then why
So-
have you included it in the list?
There is no what my lord will see if the
All right,
list,
let me
even
hear
if it
Mr. Chaudhary.
mentions,
Let me
kindly
hear,
sees the scope of the suit.
let me hear Mr. Chaudhary. Then
My lord,
I'll
let
say.
him place his application, we will contest this. Because last 3 days we hear that he's withdrawing the application. Today, suddenly, certain
Yes,
paragraph
because
5 at page 40 comes
yes,
up.
absolutely.
So
We
you have
come
already
to
got.
learn.
So we have already got the proper documents
But
with regard to
kindly
this.
see, my lord, paragraph 7 of my application.
No,
My learned friend,
there are 4 suits.
4 suits.
Now you come with other suits.
Milord, others, Milord, they're not giving the plaint, Milord. Let them show the same, whether the same letter is there in the other plaint.
But I repeat myself
have
again,
somebody who-
they are not entitled to the plaint unless they are added as a party. Only if this application is allowed, then only they are entitled
Milord,
to get documents.
This
The
is
documents are not for the asking.
this
This is not some right
this
to
is
information.
fraud on court.
All right.
Now, Milord, in my application, I have said that on inquiry, applicant learned that Mahesh Kumar Kejriwal has surreptitiously offered to pledge or has pledged the equity shares of Shri Hanuman Cotton Mills. So, Milord, I'm not sure. It's for that purpose, and my Milord apprehension has been found to be correct. Now, Milord, please see the other plaints. Milord, if in one plaint, this is Milord clearly there, and Milord, kindly see the conduct. At least 4 hearings before your lordship, they said that no, this matter is not even concerned. Now it, Milord, becomes clear that my application, Milord, is on complete correct justification. And Milord, the conduct of this person is extremely poor. Milord, he's done this with Milord LIC. He's done this with Milord CBI. Milord, one of the cases which is going on is he, Milord, obtains LIC policies, pledges them with somebody, then doesn't pay the premium on the LIC policies. So incorrect creation of pledges are, Milord, his hallmark. Milord, kindly also now see the judgment of the company law board in respect of, Milord, these shares. Milord, the judgment starts at page 6. And please, Milord, come to the concluding portion of the judgment.
Which part you are referring to?
Milord, page 6 at Milord,
Which plaint you are referring to?
Milord, my application, Milord, in the first matter. GA2.
Page 6.
Yes, Milord. Now, Milord, page 50, paragraph 60. Page 6 is, Milord, where the order starts, which is under appeal. Both I have appealed and he has appealed. He's, Milord, challenged this finding at page 51, paragraph 5. HCM, which is this company, Milord, Hanuman Cotton Mills, shall rectify its register of members by showing transfer of 1025 shares held by Mahesh Kumar Kejriwal, who's, Milord, the plaintiff number 4 in this suit, under folio number 96 to RKK, and adding such shares in favor of RKK under folio number 100. So, Milord, the company law board has directed him to transfer these shares to me.
Yes.
Now, recording of such transfers, Milord, shares had already been transferred. Now, recording has been directed. Now, Milord, this is, Milord, kindly see the date of the judgment, Milord. Please come to page 6. Date of the judgment is at page 7, 14th of May, 2013. Now, my lord, please compare this with page 40 of the first plaint. So, my lord, he loses, plaintiff number 4 loses the transfer of these
Page 40.
Page 40, my lord. Please see the date. It's post 2013
Page 40 of what?
of the plaint, my lord. Page 40 of the plaint.
Which plaint?
In the first matter, CS 155.
All four are identical. We are dealing with the first.
So therefore, my lord, please see the date. My lord, 2013, the transfer of these 1,000 shares to me is upheld. He loses, my lord, and
Subsequent to passing of this order.
yes, so he knows, my lord, he's lost. He's filed appeals in 2013, which are pending before this honorable court. We are arguing those appeals, my lord, now. They are not specially assigned to a company court. We are arguing them before Justice Roy. I have completed my arguments. They are to start. Now, my lord, during the pendency of these appeals, when he knows that these shares are not his, he subsequently offers to pledge these shares to, my lord, the defendant in this proceeding. So this is, my lord, the plaintiff's wrongful conduct. Number two, what is, my lord, very suspicious is, when I come to know of this, I come up before your lordship and I say that either these shares which belong to me are in the process of being pledged or have been pledged. Both defendants, my lord, both, my lord, parties here take a common stand that no, these are not pledged. Your lordship, my lord, is not shown the letter by which these very shares were offered to be pledged wrongfully. Your lordship is given an impression that this suit has nothing to do with these shares. So, my lord, what they really want to do is, my lord, they want to get rid of my application by, my lord, concealing from your lordship the fact that these shares are in the process of being made the subject matter of this suit. As soon as, my lord, I am thrown out by giving a wrong impression to court, by concealment, my lord, something will happen. Which is why, my lord, since my property is mentioned in the plaintiff's letter, and having regard to the wrongful conduct on their part, to protect my property, kindly, my lord, permit me to be added as a defendant in this suit. Or in the alternative, my lord, if both of them give an undertaking to court that these shares will not be dealt with in this transaction, I will not withdraw and walk out. I am only concerned with.
Next, I will hear you. Reply.
My lord.
Both of you, I will hear.
Very well, my lord.
Lord, very serious concealment, most unsavory.
আগে ডেট হচ্ছে না 17.
17th.
Grateful.
Grateful to my lord.
Heard in part adjourned to 17th May.
Grateful.
1, 2, 3, 4.
Yes.
1, 2, 3 for all, man.
Parties are different. Plaintiffs are different.
Plaintiffs are different. Defendants are the same.
Hinduja.
Same, my lord, lending. Same family.
Same
Father,
family.
Son.
Sir, I appear for the plaintiff. Your lordship had heard this application at length, my lord. If your lordship recalls, your lordship had marked certain documents as marked for identification. This is, my lord, our application so that it can be marked as exhibits. One of the documents was a bank statement, my lord, original of which, my lord, was not produced when the witness was in the box. Thereafter, my lord, it was pointed out that
What are the grounds?
I'm sorry, my
What
lord.
are the grounds? Where is the defendant?
Defendant is
My lord,
here.
I'm here, my lord.
What are the grounds?
The ground is that firstly, there was a document. The statement of accounts was actually their document. It was not pointed out, my lord, at the time when the witness was in the box that we had already given them a notice to produce, and there were orders of court asking them to produce the document. So, my lord, the photocopy of the document could not, my lord, be marked as exhibit.
Where it is stated?
My lord, I'll just indicate. And your lordship had given us leave, my lord, to file a supplementary affidavit, my lord. Over there also we have stated. Now, today, my lord, ideally, I would have liked, my lord, to place the few judgments, my lord, because we had concluded on the last occasion.
First,
I'll
your
just
pleading
refresh your
must be on the basis of facts.
On the basis of facts.
Where are
Yes.
these facts? Which paragraph you are referring to?
Yes, sir. Yeah, supplementary to it kindly takes the supplementary affidavit once, my lord. Paragraph 3 onwards. Your lordship has got the supplementary affidavit.
এটা অ্যাকাউন্ট অন কবে বলতে এইটা এইটা
হ্যাঁ
11 প্যারাগ্রাফ
হ্যাঁ ঠিক আছে ঠিক আছে Paragraph 3 onwards. And Mr. Subhashish Sengupta was arguing, my lord, on the last occasion. He indicated all these documents.
One prayer is PW2 may be allowed to produce and tender original signed seal calculation sheet with certificate 65B.
Yes, yes.
That is to be done.
That is already there, my lord. That the
And
65
second
P
is
I have already.
X for identification.
Yes.
That is done. Certificate was marked.
Lord, it was marked for identification. It was not marked as
Yet
an
to be marked.
exhibit. Yes.
no certificate was produced. The
No,
document
that was
which
not produced. That's why I
yes,
did not mark it.
my lord, my lord.
So what you want is a re-examination of the witness.
He's already in the box, my lord. I can put the questions to him.
Yes, you can do that.
Yes. Yes. If it can, my lord, be
No
allowed.
further prayer
No.
should not be allowed.
If
In
your
course
lordship
of chief, you
passes,
can say this.
Now,
if your
only
lordship
thing, my
passes an
lord,
order
the
accordingly.
cross-examination has began. And after beginning the cross-examination, that is when they became wiser and took out this application.
In that case,
I'll indicate before that, my lord. The examination on chief was concluded on a particular day. Immediately, the cross-examination began.
very good.
Once,
Let the examination, cross-examination be over. You recall the witness. I will allow this.
kindly records, my lord, that the witness will be allowed to be recalled in that case. And it can be disposed of accordingly.
My lord,
Because
there is
I have,
no
my lord,
application for recall or my lord re-examination. This is no prayer is
That
made.
is not there.
Not there, not there in the
Absolutely not there.
my lord, then I have.
Unless the witness is given chance to recall, the application is filed, there is no scope of doing this.
So for
But-
that, I need to conclude my cross-examination.
Absolutely.
No, my lord. In that case, my lord, I have to argue, my lord, on a separate aspect. This is the second point that I was taking, that the marking of an exhibit of a document is a mere formality. And this practice of
No,
marking,
it is not formality.
I'll
things are there.
satisfy your lordship, my lord. I'm carrying the judgment.
Why are you dragging this matter for unnecessary argument? I told you, let the cross-examination be over. You recall the witness. Things will be produced. If not, otherwise, problem is
Then,
there.
my lord, he'll have to be cross-examined again on these
Yes.
documents.
Of course.
So, my lord, I was suggesting, my lord, if it
Once
can
the
be,
examination chief is over, that is the only way.
my lord, subject to my lord correction. Today, my lord, if
So
the
let the argument go on. Let the suit be stopped.
this
should be
is
chopped.
something that the defendants want, my lord. I am the plaintiff. I don't want that to happen, my lord. Today, if it a mere marking of an exhibit of a document
Basic
is not, does not
prejudice that
mean-
you may suffer is that if the documents are not marked. All right.
Yes.
You will be given opportunity to produce the document
I have already produced, my lord, the documents.
on recall. That chance opportunity will be given to you. Liberty will be given to you to recall the witness.
If that is, my lord, recorded in your lordship's
Yes,
order.
I will giving you liberty in the order.
Yes.
That's
Yes,
all.
That's
Then you produce all these things.
Then I will, my lord, produce the supplementary affidavit and prove it, my lord.
Absolutely.
Yes.
GA number 7.
GA7, my lord.
GA,
My lord, I'm led by Mr. Dasgupta, my lord.
yes, GA Com 7 of 24 is filed with a prayer to mark certain documents which are tendered exhibit certain documents which were tendered and marked as X as well as X1 for identification. Full stop. After examination in chief, cross examination is going on of PW2. Full stop. These documents can be proved by the PW2 only. Liberty is given to the learned counsel for plaintiff. Plaintiff to file appropriate application, after cross examination is over, to recall the witness and to examine in chief. Full stop. Needless to say, that liberty shall also be given to the defendant to cross examine. This GA accordingly stands disposed of.
Grateful.
Grateful to my lord.
May it be fixed on an early date,
Yes.
my lord. Because he's coming from Jaipur, if your lordship recalls.
Then after vacation.
After vacation.
After vacation. Ha.
Any Friday will be convenient,
As per your lordship's convenience,
or
my
do
lord.
one thing.
Or perhaps.
My lord.
I am fixing some consecutive dates.
Yes.
Yes.
How much do you take for cross examination?
An hour should be fine. An hour should be more than sufficient.
Then 2 days.
2 days. Yes.
You come with a recall application. Immediately after cross
I'll
examination,
file it immediately, yes.
the suit will appear in the list for under heading witness action on 12th June, 13th June and 14th June.
Lord, a particular time, my lord, maybe because he's coming from Jaipur. That's
From
why.
2 p.m. onwards,
It
my lord.
was- Yes. If
At
it's
2 p.m.
At 2 p.m.
Great.
Grateful to my lord. 12, 13, 14.
Well, this is my suit. My lord, it's been transferred to the commercial division. The registry has taken necessary steps to have it marked as a commercial suit.
Statement of truth.
Item number 6, my lord.
Statement of truth.
Well, we filed. We'll file it in course of 7 days time. Lordship kindly grants me 7 days time.
The learned counsel for who is defendant?
Well, the statement of truth was already filed. So no, this has to be. There are 2 suits, my lord. There's a subsequent suit which has been filed in the commercial division. This is the 2010 suit which has been converted. So in this, we have to file the statement of truth.
The learned counsel for the plaintiff seeks for an accommodation to file statement of truth and other taking steps under Commercial Courts Act 2015. Accommodation is allowed. The suit will appear in the list on 17 June.
Great.
Wait, please, my lord.
Lord, I appear for defendant.
My lord, may I appear for
Defend
the
number
plaintiff,
1.
my lord.
My lord, this suit has been transferred to commercial division. My lord, thereafter interlocutory proceedings were pending. They have been disposed of by your lordship.
Yes.
My lord, on behalf
I
of
can remember intervention application.
my lord, on the last occasion, my learned friend.
Discoveries and inspection.
No, my lord, written statement. I need to direction
My
to
lord,
file the written
On the
statement.
last occasion, kindly take up the last order, my lord. Your lordship has asked the department to place a report as to whether the written statement has been filed or not.
That was placed. My
No,
lord
no.
has
A
seen it.
query, my lord, fell from the court whether now they can at all file the written statement or not. Last day, we were not carrying the order, my lord. My lord, may I very briefly indicate the facts? My lord, in the
Fact is, bottom line of the fact is that they have not yet filed written statement after
No.
lapse of some several years.
my lord, 17 years. My
Circumstances.
lord, my lord, and in 2011, my lord, the opportunity for filing the written statement was closed by the single bench. It was affirmed by the division bench on, my lord, on 18th July 2011. My lord, I'm carrying the orders. এটা my lord কে দিন। In 2009, my lord, they had taken out an application before the master, praying for 6 weeks' time to file the written statement. But the master allowed, my lord, it was supposed to be filed within, my lord, some June 2009 onwards. Still, my lord, after 2 years, they did not file the written statement. On 2011, they take out an application before the Honorable High Court, seeking another time, some more time to file the written statement, my lord. That application was dismissed. They appealed, my lord. The division bench has affirmed the order of the single bench, closing their opportunity of filing the written statement, my lord. If your lordship may kindly be pleased.
Have you gone through section 15.4?
My lord, kindly see 15.3 once, my lord. 15.3 contemplates a situation, the commercial, my lord, kindly take seat of 15.3 once, my lord.
Go through it, read it.
Yes, my lord. My lord, where any suit or application, including an application under the Arbitration and Conciliation Act 1996, relating to a commercial dispute of a specified value, shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provision of this act shall apply to those procedures that are not complete at the time of transfer, my lord. So, my lord, my submission is that at the time of transfer, that is
Keeping in mind the proviso of section 15.4.
my lord, 15.4, my lord, but I am carrying judgments, my lord, which says, my lord, that as per section 15, my lord, I am led by Mr. Bagman.
Mr. Bag, this
I
written
apologize.
statement shall be allowed.
Lord, kindly give me 2 minutes. I'll indicate, my lord. Why it cannot
Division
be.
bench order is there. I've seen that.
No, my
At
lord,
that
I'll
time,
indicate.
suit was not in commercial
Lord,
division.
I'll indicate, my lord. Kindly grant me 5 minutes, my lord. I'll try and canvass my
Take your
submission.
breath.
My lord.
Making passover.
Very good.
Lord, I appear for the plaintiff.
Suggested issues are filed.
Lord, the
Suggested issues.
Your Lordship, I'm preparing for the defendant. Your Lordship has, by the last order, has transferred this to the commercial suit. So today we are filing our statement of truth and list of
You are
documents.
filing this. Let the same be kept in record. Suggested issues are with you.
We are filing the admission denial. There was a mistake in the last what done, my lord. We filed the admission denial. Well, we will statement of truth has been filed. We have
Statement of truth is filed by the learned counsel for the defendant.
plaintiff. I am the plaintiff.
No, he is the defendant.
I'm fine.
File for-
List of document and statement of truth.
देखिए,
Sorry, देखे नहीं।
File on behalf of the defendant. Affidavit of admission and denial is filed by plaintiff. And this list of documents by you.
Yes, Your Lordship.
Learned counsel for the defendant files statement of truth as well as list of documents in terms of order 11 of the Commercial Courts Act 2015. Full stop. The learned counsel for the plaintiff files admission, affidavit of admission and denial of documents. All the documents be kept in record.
Yes.
So now we can frame issues.
Our documents are already in the judge's brief.
So we
all-
can go with the framing of issues.
My lord, will kindly.
Your Lordship, we have come to know from a client that the registered address, office address has been changed. So, by way of a letter, we'll intimate the
Then
plaintiff.
we have to take steps.
Yeah.
আমার নাম পাল্টে গেছে
না না অ্যাড্রেসটা
অ্যাড্রেসটা চেঞ্জ করলাম একবার
না না তো
but we corrected the address once
no you have corrected
Issues
your
may be
address
framed.
once.
That should not stand in the way of
no
framing
that
of
should
issues.
not stand in the way
That is simply matter of amendment.
yes we will make a and let them intimate we'll take out application for that and issues be framed we want to proceed with the matter
Suit will appear in the list under heading framing for framing of issues. Full stop. Next para on 19 June.
19.
The learned next para the learned counsel for the defendant craves leave submitted that registered address of the defendant company has been changed.
24th June.
Full stop. The same shall be communicated to the plaintiff or his counsel, and liberty is given to the plaintiff, on getting such information to take necessary steps for changing cost title.
May we come back on 24th of June?
24th of
Mr.
June,
Ganguly may have. Deeply up. But the statement, we have filed statement of truth.
Yes, that is mentioned.
Mention. Oblige.
এটা 8 নম্বর তো। Yes, Mr. Bag.
Please, Your Lordship. Lord, may I start first? I am placing reliance on 15.3 and I'll rely on some judgments, Lord, 3 judgments, to indicate that the very essence of the Commercial Courts Act would be lost. Lord, if 15.3 is not read together with 15.4. Before that, on the facts, my Lord. The suit was instituted in 2007. Kindly, my Lord, take up the order of 21st June 2011 passed by the Honorable Single Judge. But may I only read it? It's in 2011, my Lord, the suit of 2007. The application is utterly devoid of merit. Litigants have come to expect courts to be extremely indulgent, so much so that the written statement that ought to have been filed in the year 2007 has not been filed 4 years down the line. It appears that the master had passed an order in the year 2009 permitting the written statement to be filed subject to payment of costs. The written statement was to be filed by or about June 2009. No steps were taken to file the written statement, and the application is bereft of any particulars or plausible explanation as to why the applying first defendant was prevented from filing the written statement. GA so-and-so is dismissed with costs assessed at 500 GM. The first defendant is accordingly precluded from using any written statement in the suit. The plaintiff will be entitled to proceed against the first defendant ex parte. Now, this was carried in appeal by my learned friends. In the appeal, my lord, the Honorable Division Bench on 18th July 2011 passed the order. It reads thus, my lord. Instead of disposal of the application for stay, we propose to hear out the appeal by treating it on the day's list. This appeal is at the instance where the facts are more recorded in more details, my lord. This appeal is at the instance of the defendant in a suit for recovery of damages amounting to rupees 5 crore and is directed against an order of 21st June 2011 passed by the learned single judge of this court, by which his lordship refused to extend the time to file written statement after expiry of about 4 years from the date of filing of the suit. Being dissatisfied, the defendant has come up in the present appeal. It appears from record that the writ of summons was served upon the defendant on 2nd August 2007 at its offices at Mumbai. Affidavit of competency and vakalatnama duly executed by the competent authority of the defendant.
All right, I'll go through it.
Only
Tell me your point of law.
The point of law, that here the recording is that you could not have done it, and it is an absolute lackadaisical attitude of the defendant number 1. They have not taken steps, and after these many years,
The
it
point
was
is,
not to
in
be
view
allowed.
of division bench judgment, they cannot be allowed.
All the judgments which are on 15.4, my lord, none of the judgments, I have checked, my lord, none of the decisions which are reported are on the point where, my lord, in the previous stage, where it was not a commercial dispute, the fate was sealed. Because here in this case, it's a very unique set of facts. My lord, their chance to file written statement was decidedly, my lord, taken away by an order of the court. They challenged it in appeal. The Honorable Division Bench affirmed the order of the Honorable Single Bench, my lord. Today, if that is, my lord, not acceded to, my lord, then after 17 years, they'll be filing the written statement, which cannot be the purport of the law. Why? But kindly take up 15.3 of the Commercial Courts Act.
Yes, I've seen that.
15.3, my lord, may I only read it out, my lord, for my satisfaction. Transfer of pending cases. Subclause 1 is, my lord, deals with the cases pending in the High Court. Subclause 2 before the Civil Court, other than the High Court. And subclause 3 is what I place reliance on. Where any suit or application, including an application under the Arbitration Conciliation Act relating to commercial dispute of specified value, shall stand transferred to the commercial division or commercial court under subsection 1 or subsection 2. The provisions of this act shall apply to those procedures. Now, this is what I want to place reliance on. Apply to those procedures that were not complete. That's the phrase used, my lord. That were not complete at the time of transfer. My argument is that this step was complete. And for that, I fall back on the division bench judgment by which, my lord, their fate is sealed. It cannot be reopened. So subsection 3 says it shall apply to those procedures that were not complete at the time of transfer. My submission is, if it is complete at the time of transfer, it cannot be reopened because, may not kindly see, subsection 4, an effective reading of subsection 4 is not, it leaves to the honorable court, it's the discretion of the court as to whether a new time frame will be framed or not. The word used is may. But subsection 4 says, it reads thus, my lord, the commercial division or commercial court, as the case may be, may hold, may hold case management hearing in respect of such transferred suit or application in order to prescribe new timelines or issued such further directions as may be necessary for a speedy and efficacious disposal of such suit or application. I pause here, my lord. The essence remains the same, my lord. Speedy disposal in commercial division. For this, my lord, I am placing reliance on 3 judgments. The first being a Delhi High Court judgment. Give me the Delhi High Court. Give me the Delhi High Court first. No, the paragraph 12. This is in the decision of AIS Glass Solution. May I hand over a copy, my lord?
Reported in
I'll also hand over a copy to my learned friend. This is 2017 SEC Online, Delhi, 11467. My lord, paragraph 12 is what, my lord, I'll place reliance on. Very similar facts, my lord. This court is also of the opinion, my lord, paragraph 12, second page, my lord. This court is also of the opinion that if the defendant number 1's submission is accepted, then it would mean that the defendant in an ordinary suit who has not filed its written statement for 3 to 4 years, very similar to, my lord, our time frame, would get a right to file written statement after coming into force of the Act of 2015. The intention of the legislature while passing the 2015 Act was to expedite the hearing and disposal of commercial suits. If the submission advanced by the learned counsel for the defendant number 1 is accepted, it would negate the very intent behind the passing of the Act of 2015. And that, to my lord, while a petition was being decided, praying for extension of time to file the WS, but after the transfer to the commercial division. Here, my lord, there is no petition filed. Even if they could not have filed, that is the reason perhaps, my lord, they chose not to because of the division bench order. And they have not carried that order further in appeal. So that has become final. It has attained finality, my lord. The next decision, my lord, which I'll place reliance on, give me the 2019 SEC Online Delhi. Lord, Nirman Consultants versus NNE Limited. And this is reported in 2019 SEC Online Delhi, 11088. Lord, I'll place reliance on 4 paragraphs, paragraph 16 onwards. It deals with 15.3, my lord. After, my lord, placing, there are observations on the statement and
16, 17.
16, 17, 18, and 19, my lord. It's from internal page 16. From paragraph 16, my lord. We have extracted section 16 in the foregoing paragraphs. In our view, section 16 clearly and explicitly mandates that all pending suits and applications, including the application under the Arbitration Conciliation Act relating to commercial dispute of a specified value, shall be transferred to the commercial division. Use of the word shall leaves no room for any doubt that in such a case, the provisions of Commercial Courts Act will apply to the procedures that were not complete at the time of transfer. It is not as if the legislature was unmindful of the fact that there would be some implications on the existing matters before subsection 3 of section 15 was enacted. It was clarified that the provisions of the Act in those matters shall apply to those procedures that were not complete at the time of transfer. The question which arises for our consideration is the effect of section 15 to existing matters filed prior to the coming into force of the Commercial Courts Act 2015. In case the provisions of the Commercial Courts Act 2015 is not to be applied to proceedings which stand transferred under section 15, then in our view, it would only amount to a cosmetic change wherein only a different number will be provided to the commercial suit. In case of Videocon, the apex court was examining the effect of the amendment to section 15(2) of the Securities and Exchange Board of India Act 2012. The effect of this amendment was curtailing the right of the litigant in filing an appeal before the High Court.
I will go through it next.
This and
Study it.
paragraph 18 and 19. In fact, 18 and 19, is exactly my case, because here, what the facts in this matter was, when the matter was pending before the ordinary jurisdiction.
Because your point you are stressing on could not be complete.
Could not be complete. I'm very grateful, Here, in this decision, the facts are.
That is the key word for you.
Yes, in fact, this decision, why I'm placing reliance on is also the interpretation, other than the interpretation of section 15(3), is because, here there was an interlocutory order. From the interlocutory order, an appeal was preferred. In the meantime, when the appeal was pending, the suit was transferred to the commercial division. Section 13 was brought into effect to argue that since now it is a commercial dispute, although the interlocutory order was passed prior to the transfer and the appeal was filed before the transfer, that appeal has become infructuous. That was the argument placed before the court. That since section 30 does not allow an intra-court appeal, hence, this appeal has become infructuous. The Honorable Court held by, falling back on 15(3), that no, it was not, the interpretation would be till the transfer, whatever is complete. What was not complete, that can be espoused in the transferred jurisdiction. Here, the action was complete, the appeal was filed. So the appeal does not lose its essence and it has to be adjudicated, even though the suit has now transferred to commercial division. That is the essence of these 4 paragraphs, And the court held, by placing reliance on 15(3), that this appeal is not infructuous. The appeal can be separately proceeded with while the suit proceeds in the commercial division. Because it was not complete. That's the essence of my argument,
Any other judgment? Any other judgment?
Madhushri Konar, it's a judgment of our court, 2021 SCC Online, Calcutta 526. I'll be placing reliance on one paragraph, which, is the reiteration of the law, paragraph 8, It's reported in 2021 SCC Online, Calcutta 526, paragraph 8.
Paragraph
8, That 15(1) of the Commercial Courts Act relating to transfer of pending suits read with 15(3) makes it clear that all suits relating to a commercial dispute of a specified value shall be transferred to the commercial division of a high court, and further, that upon the suit or application being transferred, the provisions of the Commercial Courts Act shall apply to those procedure which were not complete at the time of transfer. There is nothing in the Commercial Courts Act to indicate a bar from taking recourse to the provisions of the Commercial Courts Act or the Civil Procedure Code as amended by the former once a suit or application has been transferred to the commercial court or commercial division under 15(3) of the 2015 Act. This is, the part. And thereafter also, denuding the plaintiffs of a right given under newly amended Order 13A, because it was dealing with Order 13A, where there is no statutory bar for disallowing the plaintiffs, would amount to curtailing the scope of the scope and objective of the 2015 Act of speedy resolution of disputes. That's also, what I am stressing on. Because if, the written statement is permitted to be filed after 17 years now, that would be against the objective of the Act. And the rest is, on the on the facts of that particular case.
These 4 judgments.
These 3 judgments,
No, you have produced 3 or 4?
3, 4. 3,
Calcutta, Delhi.
Calcutta, Delhi, and there are 2 Delhi judgments, 1 Calcutta.
Any reply?
My lord, so much so has been said about the defendant's conduct. My lord, the dishonest plaintiff. I am an association of the airliners all over it.
I am not going into the merit of the suit.
Kindly bear with me for it. My lord, otherwise keep it some other day. The counsel has not come today. I
say that.
Very well.
Because I am not going into merit. Only
no, my lord, my learned friend had contended so much about not that attempt was not made for filing written statement.
That is separate
the
issue.
Court's decision.
End of the day, written statement has not yet been filed.
My lord.
That is very clear picture.
There's no
now,
denial
what is your
on
defense?
Very well, my
It's
lord.
the point
Kindly
of-
any other day, my lord. Kind.
Heard Mr. Bagh, the learned counsel for the plaintiff in part. Plaintiff. adjourn to the learned counsel for the defendant.
Defendant number one.
Defendant number one craves leave, craves for submitted, prays for accommodation, prays for an accommodation, adjourn to 21st May for further hearing.
Very
Deeply
obliged.
Or after vacation, come after vacation. 14 June.
Deeply obliged, my lord.
Item number 11.
You are
Well,
for
I am on the
defendant.
plate.
Plaintiff, where is the defendant?
My lord, I believe he's sitting outside, my lord.
PW1 will be examined.
Yes. My witness.
Your client is here?
Yes, it's my client. বাইরেই আছেন। My lord, I am being led by Mr. Bose.
Where is your adversary?
My lord, they are here.
Yes, bring your witness.
আমাকে প্লেনটা খুলে দে একটু। In this suit for the My lord may recall, this is on a very short point. It was a suit for eviction. At one stage, the parties thought that they would settle the matter. It went to mediation. It could not be settled. In the meantime, the defendant had written us 3 letters wanting to fix dates on which they would vacate the premises. They have since vacated the premises. We have got possession. The claim rises now, which is left to be adjudicated. We say we are entitled to mean profits. Now, the mean profits can only be calculated provided there is a decree for eviction. So basically, we will just have.
First, decree of for eviction. Second thing, whether unlawful possession.
Yes,
That is to be decided.
yes. Well, the
Unless
fact-
this is done, there cannot be.
Yes. But the main thing is, my lord, the question is the very fact that they have written so many letters.
We
saying-
start an examination of witness. The question of law shall be decided later on. Now you start an examination.
कृष्ण कुमार बियानी कृष्ण कुमार बियानी BIYANI
My lord, kindly grants me a moment, my lord. Mr. Biani, how are you connected with the plaintiff Turner Morrison Limited?
I'm
But this is a commercial suit. You should
Yes.
file affidavit, no, evidence on affidavit.
Yes.
That should be done.
Yes, it has been done. I shall show him the affidavit. How are you connected with the plaintiff Turner Morrison Limited?
I'm employed with the plaintiff company as vice president and company secretary since 90.
Be slow, be a little bit slow.
I'm employed with the plaintiff company since 1996 as vice president and company secretary.
Why have you filed this suit against the defendant?
For recovery of peaceful and vacant possession of the premises from the defendant.
Would you describe the premises before my lord?
This is an office space measuring around 12,125 square feet office space at second floor of premises number 6 Lions Range, Lyons, Lyons Range, Calcutta, Lyons Range, Calcutta 7,01,000.
I am showing you a document affirmed on 11th March 2024. Kindly look at this document and tell my lord what this is.
So this is an affidavit of evidence of claimant. Affidavit of evidence of claimant in CS number 230 of 2008.
Who has affirmed this affidavit?
It is affirmed by me, myself.
Does your signature appear on
Yes.
this
Yes.
affidavit,
Yes.
showing that you have affirmed the same?
Yes.
Are the contents of this affidavit true and correct?
Yes.
Are the annexures to this affidavit true and correct?
Yes.
Under whose instructions was this affidavit prepared?
Under my instruction.
But I'm praying for leave to tender this affidavit.
All the documents are original, or that is explained there?
Yes. The originals are here, my lord.
The original may be produced for marking.
Very well. I'm showing you a bunch of documents. No, I'm just no. For that obvious reason. Very well. My learned friend wants me to prove them one by one. I shall do so. I am showing you a document dated 7th May 1984. Kindly tell my lord what this document is.
So this is an agreement dated 7th May 1984 for creation of tenancy in respect of suit premises with effect from 1st May 1983.
Who has signed this document?
This document has been signed by Mr. H.K. Chaudhary, the then director of the plaintiff company. H.K. Chaudhary, Mr. H.K. Chaudhary, the then director of the company, and Mr. V.C. Jain as general manager.
Do you know their signatures?
Yes.
Has anybody signed this document on behalf of the defendant?
Yes. Yes. It has been signed by Mr. S.C. Agarwala, Assistant General Manager, S.C. Agarwala, Assistant General Manager, National Insurance Company Limited.
Do you know his signature?
No, I do not know his signature.
Are the contents of this document true and correct?
Yes.
Has this document been acted upon by the parties concerned?
Yes.
Well, I'm praying for leave to tender this document.
Lordship, this I have an objection.
Let it go down subject to objection.
Once it is marked exhibit, then it cannot be impounded. This is a tenancy document, lease document, rather more than 11 months. And Lordship, it is not stamped. Now, Lordship,
Objected to.
so Lordship, kindly don't mark for identification. Once it is, Lordship.
It will be marked exhibited on objection. If you want to impound it, file application.
Lordship, kindly keep it identified. Once it is marked, even with objection.
Marking makes no difference.
But Lordship.
What do you want?
Under the stamp.
Not to mark it.
Lordship, once
not to produce this document.
Yes. Mark for identification.
Are you denying the signature?
I'm saying mark for identification.
Exhibit A.
Grateful.
With objection.
I'm now showing you a document dated 19th July 2008. Kindly tell my lord what this document is.
This document dated 19 July 2008 is a notice under Section 106 of Transfer of Property Act 1882, given on our instruction by our advocate and record Sandeep Agarwal. These and advocate and record Sandeep Agarwal and company. These and Sandeep Agarwal and company. Addressed to the defendant.
Under whose instructions was this notice sent?
Under my instructions.
Where is the original of this letter?
This is the original letter duly acknowledged by them.
By them, what do you mean?
By defendant.
How do you say so?
It bears rubber stamp of National Insurance Company. It was rubber stamp of National Insurance Company, which was received on 21st July 2008.
My lord, kindly grant me a
Sir,
moment.
I want to add further. The notice was also served with the registered with AD.
Registered?
The AD card is
Registered
available.
post with acknowledgement due.
Yes. Acknowledgement. This also was received as it will appear from the rubber stamp of National Insurance dated 25th July 2008.
Original AD cards. These are all original AD cards.
Yes.
Mark it.
Yeah. Original.
Were these original registered? Sorry. আমি একটা আরেকটা প্রশ্ন করে দিই। Were these registered acknowledgement due cards received by you in the usual course of business?
Yes.
My lord, I'm praying for leave too. Ended. I am now showing you a letter dated 1st April 2022.
এগুলো অ্যাকশন করো
I'm okay.
সিআরডি কালেক্টিভলি করে দিন
Okay. I'm now showing you documents dated 1/4/2022, 26/5/2022, আলাদা দেব। Kindly tell my lord what these documents are.
These are original documents.
Yes.
The first document is a letter dated 1st April 2022, written on behalf of defendant company, addressed to Vice President of plaintiff company, intimation of surrender of possession. Intimation of surrender of possession. It is indicated in the letter that suit premises is going to be surrendered on 31st May 2022 at 4 p.m. and we have been requested to receive the possession of the same on that date. To receive the possession of the same on that date and time.
Next letter.
There is another letter next is 26th May 2022, written by the defendant company, addressed to me as a Vice President of the plaintiff company regarding subject surrender of possession. Here in this letter, surrender of possession, subject. Hmm. Here they have indicated arising out of some unavoidable and pressing circumstances. Pressing circumstances. We would not be in a position to vacate the said premises on 31st May 2022. They have indicated that a revised schedule for vacating the premises will be communicated. The premises will be communicated shortly.
Were these letters received by you in the usual course of business?
Yes.
My lord, I'm praying for leave to tender these documents collectively.
Exhibit C and D.
Very well. C and D separately. I am now showing you a letter dated May 27, 2022. Kindly tell my lord what this document is.
So this is a letter dated 27th May 2022, written by me on behalf of plaintiff company, addressed to defendant company. In this letter, we have written to them that you are expected to comply with the letter dated. You are expected to comply with your letter dated 1st April 2022 for handing over vacant and peaceful possession of the fruit premises on 31st May 2022. However, in case you fail to do so, you will be held responsible. You will be held responsible for payment of compensation.
You need not read out the content of the document.
Okay.
You just produce it.
Okay.
Who has signed this document?
It's signed by myself, and it was received by National Insurance on 27th May 2022.
National Insurance.
Their rubber stamp is appearing.
27th May 2000.
My lord, I'm praying for leave to exhibit this. I'm now showing you another document dated September 26, 2023. Kindly tell my lord what this document is.
This is a letter dated 26 September 2023, written by different company, written by Georgie Roy, Chief Regional Manager,
You don't
Chief-
have to say all this, just on the defendant company.
different company. They have intimated by this letter, kindly take possession of the premises on 29 September at 4 p.m. 16 hours.
Did you receive this letter in the usual course of business?
Yes,
Have you since taken possession of the premises?
yes.
My lord, I'm praying for leave.
What is the date of taking possession?
29 September 2023.
I am now showing you, my lord, I'm praying for leave to tender.
Yes.
Exhibit. I am now showing you an order dated 30th of April 2009. Photocopy of an order dated 30th of April 2009, passed by the Honorable High Court. Kindly tell my lord what this document is.
देखिए एक document देखिए.
just to show, my lord.
But this will not be marked whether interpolation.
Yes. It's a matter of record. It can also be argued. But since I have two subsequent documents, that's the only reason.
Sir, decision order of Honorable Calcutta High Court.
An order of
Honorable Calcutta High Court in GA number 1064 of 2009 in CS number 230 of 2008 between plaintiff company and National Insurance Company and National Insurance Company Limited, Division 1. The date of order is 30th April 2009.
X for identification.
I'm now showing you two documents. I'm now showing you two documents dated May 8, 2009 and May 20, 2009. Kindly tell my lord what these documents are.
Both the documents are written by Mr. Amitabh Chanda, Assistant Manager of Defendant Company, regarding payment of rent for the month of 2009 in respect of the suit premises. Another letter dated May 20th, 2009. First letter date is May 8, 2009. Forwarding the with check for payment of rent for May 2009 to the plaintiff company. The another letter is May 20th, 2009, written by defendant to the plaintiff company, forwarding therewith payment of rent for September and October 2008.
Did you receive these checks?
Yes.
Were these letters received by you in the usual course of business?
Yes.
Did you encash the concerned checks?
Yes.
What relief are you now claiming in this suit? Well, these have to be tendered, man.
What is your prayer before this court?
Mr. Profit, sir, we have already got possession of the premises. Mr. Profit.
Min profit.
Yeah, min profit.
Well, that is all.
and 2009.
Well, that is all.
Cross.
Mr. Bihani, have you produced any document to show that you are authorized by your company to depose in this matter?
I am principal officer of the company. I have not produced any document.
And the principal officer.
I have affirmed this petition.
Affidavit, not
affidavit. Myself.
Mr. Bihani, is it your evidence that there is no board resolution passed so far by the company authorizing you to depose?
My lord, I don't want to interrupt. When the suit is filed, my lord, it is filed on the basis of an affidavit of
Let
competence.
the cross-examination be given, be allowed. It is for testing veracity. Yes.
Kindly repeat your questions.
Mr. Bullet.
The board resolution and power of attorney was produced before the court officer at the time of filing the affidavit.
Mr. Bihani, is it your evidence that the document is not on record?
That I can't say.
I can't say whether any document is there on record. Mr. Bihani, can you apprise the Honorable Court who is the owner of the premises number 6 Lion Range?
The plaintiff company is the owner of major portion of 6 Lions Ranch and particularly the suit premises. The suit premises.
Mr. Bihani, can you explain to the Honorable Court what do you mean by major portion of 6 Lions Range?
Some portions of the premises, 6 Lions Ranch, were sold and major portion is still retained by the plaintiff company. Yeah. Retained by the plaintiff company as owners on ownership basis.
Mr. Bihani, since when you have become, means the plaintiff has become the owner of the suit premises?
This company is as old as 1913 company and 1913 company.
Companies under 1913 Companies Act.
Yeah,
That's what you
Companies
want
Act.
to mean.
And it was registered in 1913. And
1930 or 13?
13,
Taro.
13. And this premises is as 100-year-old premises.
I repeat the question, Mr. Bihani. You carefully listen to it and answer. Question to repeat করে দিন sir.
It's more than 50 years or 50 or 60 years old company. Ownership is more than 50 or 60 years old.
You have made the statement with regard to the period of ownership is based on any document or from your imagination?
From the company's records, I'm talking about it. I can't tell you the exact date. I can't tell you the exact date right now.
Did your company purchase this property by way of by registration of deed of conveyance?
Yes, the property was purchased and conveyance deed is already registered one.
Can you produce a copy of the conveyance deed before this honorable court?
If so, if
I understand what will you ask.
yes, I can produce photocopy of the same can be produced. Original can be shown.
Since when National Insurance Company is in possession of the property?
1st May 1983. As would be evident from the agreement already placed before this court.
Is it your evidence that before execution of your agreement, which is dated 7th May 1984, the defendant was not in possession of that property?
The defendant was in possession of the property. Some litigation was going on, and that litigation was, and by virtue of settlement, this new tenancy was created.
So your evidence is this, that the defendant was in possession of the property prior to 7th May 1984.
That is a matter of record.
Kindly apprise the court by saying yes or no.
Yes.
Mr. Bihani, can you apprise the court whether the defendant was in possession of the property even prior to purchase of the property by the plaintiff company?
Can you repeat the question?
Can you apprise the court whether the was possession of the property prior purchase of the property by the plaintiff company?
No.
Can you apprise the court when the defendant company was first introduced to the property?
So this is a very old record. It is not known to me.
Can you apprise the Honorable Court after consulting your record on the next occasion, if so arise?
Yes.
Can we take that later in? After receiving their letter, can you identify whose signature is appearing at the bottom of the letter on behalf of the plaintiff company? I'm sorry. Mr. Bihani, kindly identify the signature appearing at the bottom of the said letter who signed on behalf of the plaintiff company.
That is Mr. Srikanth, one of our executive of the company.
This is your document.
My document, signature is his. When I handed over the
So
document,
it will be marked as Exhibit 1.
no, it is already marked exhibit.
Executive of the plaintiff company.
This
Only-
much today.
Yes, only signature was not identified by my learned senior friend. So I got it identified and he
You
had
encircle it. Come on the next day.
Lordship.
9th. 9th May.
As your lordship pleases. As your lordship pleases.
Will you come on 9th May?
If your lordship allow me little a week's time, because I will take out that application. So if your lordship kindly keeps it on the next week.
Srikanth.
21 then.
21. Obliged, lordship.
Exhibit 1.
But it has already been exhibited by us.
Signature is produced by them.
Very well.
So it's encircled and identified. I'm obliged.
PW1 is examined in chief and partly cross-examined. Further cross-examination is adjourned to 21st May.
Obliged, Lordship.
Well,
The plaintiff, my lord. My lord, I am for the defendant, my lord.
No, my
Mr.
lord, last occasion, my lord, they had raised an issue with regard to, my lord, the affidavit, my lord, the evidence not be correct. I don't understand what reasons, my lord. However, my lord, in their affidavit on evidence, their own letter, they have denied it.
maybe
You
they
want to
produce
get
it.
into that, my lord, kindly
That is
fix a
separate
date
issue.
for a witness to come, my lord.
Not yet come today.
No, my lord, obviously, my lord, for this reason it was kept, my lord.
You produce this document.
I'll produce, my lord.
Yes.
For orders, it is there. That is the reason, my lord. Kindly, my lord, see the last order, my lord.
My lord, Mr. Pranit Bag is appearing in the matter, my lord. My lord, may I pray for a very short passover, my lord?
Issues are framed or not?
Yes, framed. Issues framed too. Issues?
Only for further order.
Long time before issues frame, my lord. That is the reason my witness had come on the last occasion, one of the occasions, my lord. Wasted.
So I'm adjourning it.
Yes, my lord. For witness action on, my lord, any day, my lord.
For witness action.
Any days, my lord. I'll come up, my lord.
On prayer of the learned counsel for the plaintiff, the suit is adjourned to 18 June for witness action.
Grateful, my lord. 18 June come back.
Grateful, my lord.
Correction হবে, cost title correction হবে.
I
Name
put
total
respondent,
দেখে
my lord.
Yes. নামটা দেখে করে। There should be correction in the cost title of the judgment.
Yes, my lord, we have already given the corrected year for
The first, let me my order that
for judgment, for issuing the judgment.
unless the judgment be corrected, how they can go ahead?
Now they have given another letter.
রিপোর্টটা কোথায়? জাজমেন্ট পুরোনো যে যার নাম আছে গুরুপদ হচ্ছে মারা গেছে, প্রেজেন্ট কস্ট টাইটেল দেখে ওটাকে করে দিতে হবে, অ্যান্ড আদার্স করে দিতে হবে, করে একটা অর্ডার করে দিন। ইয়েস, নেক্সট judgment will be corrected.
Well, it is the matter relating to the Charushila Trust estate. Lordship's last order, my lord directed the receiver to collect the key from the erstwhile receiver in the presence of the
That was
registrar.
done
or
as
innocent.
inventory.
Yes, my lord. And my lord.
Inventory produced.
Representing the learned receiver, my lord, may I file my report, my lord?
Yes, my lord.
My lord directed me
May
to
I
file the report
copy-
after opening.
Let me see it first.
Yes, my lord. Let us consider that and come back.
It should be signed on every page and dated. There is no date.
না দেবে, জজ সাহেব বললে তারপর দেবে।
G13 of 2022 আজকে হ্যাঁ এখানে একটু আগে দুটো একসাথে appear
Report of the learned receiver bearing date 6/5/24 is placed before this court. Full stop. Simultaneously, at the same time, another report is submitted by the learned register original site bearing date 3rd May 2024. It is mentioned in the report of both the report, mentioned in both the reports that the erstwhile receiver had taken back some of his personal belongings through his son, who was present at the time of making inventory. Full stop. It is also in the report of the learned receiver that some of the belongings are still in the room
of the erstwhile receiver.
of the erstwhile receiver, semicolon. The son of the erstwhile receiver assured to take the remaining at a future convenient date. Full stop. It is ordered that without permission of this court, not a single piece of material or document shall be handed over to any person whatsoever.
Deeply obliged, my lord.
This report may be circulated, may be handed over, copies of this report may be handed over to the parties for their perusal.
Grateful, my lord.
The suit will appear in the list on 27 June. The learned present receiver shall submit an inventory and statement of accounts
Yes, my lord.
on that date.
Grateful, my
May I,
lord.
my lord, just pray for one indulgence? My lord, my application is GA13 of 2022, where my lord, I have prayed for my lord intervening in the matter, and also my lord,
Next date.
The next.
The inventory is in the report, my lord. Inventory is in the report, my lord. I've made the list.
Earlier order a part inventory, I believe.
Have you checked the account?
No, no, that
Statement of accounts is not there.
no.
That should be prepared.
Yes, sir.
Well, there was a direction
Grateful.
in this application, Malad, there was a direction upon us to serve the learned receiver. We had effected service upon the learned receiver, Malad.
That is J number 13.
13. Malad, the receiver may Malad.
Affidavit is complete.
No, Malad, that's what I'm saying. That the affidavits have not been filed. Lordship, at least direct Malad for affidavits to be
But
complete.
only thing, Malad.
J13 is filed by the intervener.
No.
Yes.
Copy of this. Have you served the copies?
Yes, my lord. My lord, all
got the copy.
Well, these are the allegation against the erstwhile receiver. Now the receiver
Have you
has
got copies?
Yes,
or
my lord.
not?
Yes, my lord. My lord, I have.
Copies
Yes.
served as submitted.
Intervention, my lord.
Parties shall exchange affidavit on or before the returnable date.
Deeply obliged, my lord.
I'm so grateful.
Why?
Thank you.
What do you have to do with this copy?
But the tenant has no locus.
What do you have to do with this copy?
এটা object করতে হবে।
Several of us presented for the honorable court.
Present dispute is not
Tenants are
concerned
carrying
with
the
any
will of-
tenant, so no copy will be handed over to the tenant.
Let the
ওটাকে লিখে দাও তো,
receiver take
copies
care
of this
my lord.
report may be handed over to the learned counsels for the trustees.
Deeply obliged, my lord.
Grateful, my lord.
Lord, only to the upon the trustees.
Yes,
No, my lord, we.
Then
yes,
No, my lord, may I point out? May I point out, my lord? The order, my lord, this matter had been hibernating for, my lord, many years. This was resurrected by us. And it's in our GA 13, my lord, that your lordship had passed an order, my lord, for an inventory to be done because we had made allegations of our areas being shrunk and new people having been gotten. Despite, my lord, the court restraining the receiver from, my lord, including anyone new, we have been given, my lord, at all points in time, even earlier, copies of all the reports which have been filed.
আরেকটা জিনিস লিখে দাও তো, receiver shall submit a report, shall submit statement of accounts and state condition of the premises.
My lord, one tenant gets if all tenants will
No,
demand.
my lord, I am,
Make the situation
I
precarious.
have a pending application, my lord.
Well, let him
Have
come
I,
on the next
have
day.
I passed order to hand over?
No.
Then why are you making submission unnecessary?
My lord, I tender my apology, my lord.
Next matter.
Grateful, my lord.
Lord, then may I take it back from this? The report I have served only upon the trustees. Obliged to Lord.
Grateful.
Lord, I appear for the plaintiff respondent. Lord, in this matter,
It's my application. দাঁড়াও না, বুঝতে বড্ড হুড়ুড়ি করো আজকাল তুমি।
Lord, before my learned senior friend starts, my Lord, I am humbly praying for a week's time to file my affidavit in opposition in this, my Lord.
Yes, they have not used the opposition yet. The order was passed long back, my lord.
Lord, since the application involves certain allegations against the erstwhile advocate who was representing the defendants, Lord, we had personally written a letter to the advocate who was appearing. And Lord, we are awaiting a reply.
This is only prayer for liberty to the petitioner or defendant to adduce oral evidence.
Yes, my Lord.
This
But-
much. What is the problem with that?
Yes, my Lord. But in the application, my Lord, several allegations have been leveled against the
That
erstwhile
will not
advocate.
fit him to be admitted.
My Lord,
I'm allowing this.
my Lord, my Lord will kindly give me leave, my Lord, to file an affidavit in opposition a week's time, my Lord.
Should this court investigate into those things, those allegations? Should it do?
My Lord,
Should
we
it
are
do?
simply awaiting a reply from the learned advocate. My Lord, if that comes,
We are
we will
not
file.
concerned with that. I am not taking these objections or all these allegations as admitted. This court will not divulge from this its root. Why
Lord,
should I do this?
my Lord will kindly allow me a week's time to come back. My Lord, I have a senior in this matter. My Lord will kindly allow me to come back in this.
Look, keep one thing in your mind. I will not delay this matter and I will allow this application. Plaintiff's witness is over.
Yes, my Lord.
So there will be no digression from the suit, from proceeding with the suit. If you want to do this, not only I will allow this application, but for this delay, I will impose heavy cost upon you. Keep it in your mind.
But I must indicate the reason of objection because it was submitted before the court that we will not adduce evidence. That we submitted
Court
initially.
will not do that. Court will
Yes.
not go into that.
Yes, I am on merit. Let's go on merit. That's what
Keep it in your mind.
that we
I am
submitted. We
allowing
will not
today
adduce evidence. That's
But
the only
in this
thing we have
matter-
done, if at all wrong.
on prayer of the learned counsel for the plaintiff. You are plaintiff.
Yes, my Lord.
Plaintiff. The matter is adjourned to
Hello.
28th June.
Hello.
20th June কি জানি না হ্যাঁ বললো না
Obligement.
Lord, I am for the special officer of the respondent number 1.
Thank advocate. I'm for the plaintiff, Lordship. I'm praying for not intervention. Fear of the
Use microphone. Use microphone. You are praying for time.
yes, Lordship. Kindly
I've
take
heard
it
it
up to
possibly.
vacation.
Yes, yes. Milord, this is a matter, Milord, where the administration of the club, Milord, is an issue. Now, Milord, I had taken out an application. Their application is that they want to withdraw the suit because the club is no more interested in pursuing the suit, the plaintiffs. And I had pointed out, Milord, that the suit was instituted after.
Last day order was passed, striking out the name of the plaintiff who died.
Yes. Now, Milord, I have filed an application which is GA3, Milord. Since an order 1 rule 8 suit, the suit cannot be.
Just a minute. GA2 was not disposed of.
There was a direction to file opposition. They have not.
GA2 and 3 shall be taken up today.
Yes, that direction is there. And the plaint was also directed, and they have not filed an opposition to my application either.
Plaint is amended. None.
No, no, Milord, Lordship passes, if Lordship allows GA3, allowing some of the defendants who are the present club members, the president secretary to be transposed as plaintiff, then all the amendment can be done in one go, by one order. The plaint was directed to be produced. It will be produced. Courted direction থাকলে আপনি আসবে.
Have you copy of plaint?
Yes, Milord. I copy of plaint আছে? Oh, no, Milord, we don't have a copy of the plaint.
Then the matter will go.
Matter will go where?
No plaint. They have submitted report.
Learned friend is for the plaintiff, Milord.
Have you copy of plaint?
I'm no holding the brief, Lordship.
Then
I'm
কিন্তু
instructed by
reconstruct
the
করতে গেলেও তো একটা copy
learned
হবে।
advocate.
A report of the old superintendent of the old record department dated 13/2/24 shows that search of the plaint is going on, but could not be traced as yet. The learned registrar original site shall cause search of the plaint to be carried out on or before the returnable date. Full stop. In case the plaint is not found, order for reconstruction may be passed. Both GA2 and 2 of 23 and 3 of 24. Because even if I allow your application, that would be useless.
Yes, I have to put it somewhere in the record. Yes, I understand.
Appear in the list. কি বললাম? Reconstruction will be, order of reconstruction shall be made. Let the matter appear in the list on 20th June.
Deeply appreciate.
Let the plaint come first.
Yes, Milord, it has to. Milord. That otherwise we will reconstruct it.
Even if the application 2 is to be allowed, withdrawal of the suit, then also I need the plaint.
Yes, it has to be somewhere on the indication. My learned friend is appearing for the plaintiff. Milord, a direction may be passed on the
No,
plaintiff.
let this first searching may be carried out.
If they
Then
have a copy
that's
of
why
the
my
plaintiff
order is.
also, then it will be easier for the registrar also to
Do one thing. Try to get a copy of the plaint.
Yes, that is what I.
Next day, if it is not found, I will pass order for reconstruction.
Your Lordship, I'm appearing on behalf of the plaintiffs. Your Lordship, in this matter, Your Lordship, some of the defendants have taken out an application, Your Lordship, for deletion of the name. Your Lordship,
That is
in that-
GA2.
Yes, Your Lordship, in that directions were passed for filing of affidavits. We are out of time, but our affidavit is ready. Can we file the opposition?
My Lord, I appear on behalf of the defendant. Am I audible, my Lord?
Yes, yes.
My Lord, this is not an application for deletion, but this is an application for dismissal of the suit because there are no defendants which is in existence today. I'll tell your Lordship why. My Lord, the entire suit of Union of India was against defendant number 1. and the defendant number 5 was also made a party to the proceedings. Now, the defendant number 1, under a scheme of merger, merged with the defendant number 5. So, the existence of defendant number 1 ceased to exist upon the merger application or the scheme of merger having been allowed under section 391 of the Companies Act. Then the defendant number 5, against in an insolvency proceedings before the National Company Law Tribunal, an order of admission was passed on 8 January 2018. Pursuant to the order of admission, there was a section 14 application, section 14 moratorium, which was operative against the defendant number 5. Subsequently, on a resolution plan, which was initially approved by the Committee of Creditors. One more minute, thereafter, the plan has been approved. Once a plan is approved under the Insolvency and Bankruptcy Code, the plaintiff's claim, if any, has to be relegated to the plan, and there cannot be any substances of a suit against the entity which is no more in existence.
Yes. So that is your point. Grounds dismissal of suit.
Yes, well, there's nothing remains. So their cause of action today, in terms of the judgment of the Supreme Court in the case of Ghanshyam Mishra, is to lodge their claim, and their claim will be considered in the resolution plan initially by the Committee of Creditors, and thereafter it has to be approved by the adjudicating authority, which is the National Company Law Tribunal. So they cannot independently pursue against the corporate debtor, which is now in the corporate insolvency resolution process. Because the law is absolutely clear now. You cannot proceed any further. Your claim has to be relegated to the plan, and if the plan fails, subsequently liquidation. But you cannot pursue your cause of action against a entity, a juristic entity which is no more in existence in law. Well, these are my limited submissions.
I'm the dominus.